We now arrive at one of the most significant contract writing developments in modern Arizona real estate practice. The seller compensation addendum exists because the real estate industry fundamentally changed following national litigation involving the National Association of Realtors (AR) and buyer-broker compensation practices. Arizona agents must now understand that compensation is no longer assumed through MLS cooperation. Compensation must be negotiated, documented, and agreed to in writing inside the transaction itself. This addendum serves as the contractual bridge connecting buyer representation agreements to the purchase contract and escrow closing instructions. In today's marketplace, compensation clarity is no longer optional risk management, it is mandatory professional practice. Why this form now exists: industry change after buyer representation lawsuits. For decades, buyer-broker compensation was commonly offered through MLS systems as cooperative compensation between brokers. Following industry settlement changes, MLS systems no longer function as compensation marketplaces. Compensation discussions now occur directly between parties through contracts. This means buyer brokers must secure written authorization showing who will pay compensation and how payment will occur. The seller compensation addendum provides that written authorization and protects all parties from misunderstandings at closing. Without this form, a buyer-broker may successfully represent a buyer, yet have no enforceable agreement requiring payment from the seller. Contract writing integration. How this addendum connects to the buyer-broker agreement. Earlier in this chapter, students learned that the buyer-broker exclusive employment agreement establishes compensation owed by the buyer to their broker. However, buyers often request that the seller contribute toward that compensation as part of negotiations. The seller compensation addendum transfers payment responsibility contractually to the seller when agreed upon. This creates alignment between three documents working together: the buyer-broker agreement establishing compensation, the purchase contract establishing transaction terms, and the seller compensation addendum identifying payment source. When properly drafted, escrow receives clear written instructions regarding broker payment, eliminating disputes during closing. Arizona example buyer representation in Queen Creek. A buyer signs an exclusive employment agreement agreeing to compensate their broker 2.5%. The property selected does not advertise compensation. The buyer submits an offer including a seller compensation addendum requesting seller payment of 2.5% at closing. Seller accepts the contract. Because the addendum becomes part of the purchase agreement, escrow now has written authority to disburse compensation directly to the buyer-broker. The compensation obligation becomes enforceable contractual consideration rather than an assumption or expectation. Sale transactions versus lease transactions. The addendum allows compensation to be structured for both purchase and lease transactions. In a sale, compensation may be written as a percentage of purchase price or fixed dollar amount payable at close of escrow. In leasing scenarios, compensation may be calculated as a percentage of total lease value or a fixed fee payable upon lease execution. This flexibility allows Arizona brokers to maintain compliance whether assisting buyers purchasing homes, investors acquiring property, or tenants entering long-term lease agreements. Compensation is separate from seller concessions, critical lending concept. Students must clearly understand that broker compensation written in this addendum is not the same as seller concessions. Seller concessions benefit the buyer directly by reducing closing costs or prepaid expenses. Broker compensation pays for professional representation services. Mixing these concepts can create underwriting problems. For example, if compensation is incorrectly written as a concession, lender contribution limits may be exceeded, potentially delaying or terminating loan approval. Proper contract drafting protects financing approval and transaction stability. Third-party beneficiary protection, why brokers gain enforcement rights. One of the most powerful legal elements of this addendum is the third-party beneficiary language. Buyer and seller explicitly acknowledge brokers as intended beneficiaries of the contract regarding compensation. This allows brokers legal standing to enforce payment obligations if disputes arise. Even though brokers are not principals to the purchase contract, this provision allows compensation enforcement consistent with Arizona contract law principles. Importantly, these provisions survive closing, meaning disputes discovered after escrow may still be enforced. Multiple compensation source disclosure transparency requirement. The addendum also confirms written consent allowing a broker to receive compensation from more than one party to the transaction. This disclosure prevents undisclosed dual compensation concerns and aligns with Arizona Department of Real Estate professional conduct standards requiring transparency. Buyers and sellers must understand exactly how brokers are compensated and from whom payment originates. Transparency protects licensees from claims of hidden compensation or undisclosed financial benefit. Broker supervision and documentation responsibility. Under Arizona Administrative Code R4-281103, designated brokers are responsible for supervising contract documentation within their brokerage. Improperly documented compensation agreements frequently result in commission disputes and ADRI complaints. Best practice requires brokers to ensure the seller compensation addendum is uploaded into transaction management systems such as SkySlope immediately upon execution and retained pursuant to ARS. Paragraph 32, 2151.01, Record retention requirements. Compensation discussions must always end in written documentation. Arizona brokerage scenario. Contract failure without addendum. An agent represents a buyer in Mesa. Buyer assumes seller will pay buyer broker compensation because that's how it always worked. No seller compensation addendum is included. Seller refuses compensation during escrow. Buyer remains contractually obligated under the buyer-broker agreement to pay their broker directly. The dispute damages client relationships and risks complaint filings. Proper use of this addendum would have prevented the conflict entirely. This example demonstrates why modern contract writing requires proactive compensation documentation. Discussion question: should a buyer-broker rely on verbal confirmation that the seller will pay compensation? Answer: no. Compensation must be documented in writing through the seller compensation addendum or purchase contract language. Verbal agreements are not enforceable escrow instructions. Discussion question: can broker compensation be paid in addition to seller concessions? Answer: yes. Compensation under this addendum is separate from concessions unless specifically structured otherwise in the contract and approved by the lender. Discussion. Question: why does the addendum state that broker compensation survives closing? Answer: because it preserves enforcement rights if payment errors or disputes arise after escrow closes.